Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have a ruling from the judge in Justin Baldoni versus Blake Lively, and I think you guys are going to like this one a little bit better, but just hold on a second while I pull this up. But I am actually, just to let you guys know, because I just kind of figured this out, I'm going to be talking to Shasti Flaw tomorrow morning at 9 a.m. Eastern. I don't think that's going to be a live thing. I don't think so, but, you know, I'll let you guys know what time that'll come out if not. So that's going to be fun. Let me see where I could get this. I always pull things up and I have them ready, and then I'm like, what did I actually do with that? You need me to move my head. There we go. All right, so we'll read through the ruling. It's not too long. You can't hear. Can anyone else hear? I don't want to talk too much if you can't hear me. That'd be like pulling an Omar, you know? Omar's pretty notorious for going off on some impassioned rants when he has himself on mute. Okay, cool. All right, let me just get through this because I want to go do some other stuff after this. So, all right. Blake Lively moves for protective order, relieving her from producing documents responsive to requests numbered 108 and 109 in the request for production served by the Wayfarer parties on February 21st, which request all documents and communications relating to or reflecting Lively's communications with Taylor Swift relating to the film or the action. The Wayfarer parties oppose the motion, and they cross-move for an order compelling Lively to produce documents responsive to these requests and certain other requests for production. Lively moves to file a reply to the opposition and cross-motion. The motion to file a reply is granted. Lively's motion for a protective order is denied, and the Wayfarer parties' cross-motion for an order to compel is denied. So that I did kind of skim over this, and it sounds like it's just going to be a matter of timing, but we'll go through it, and maybe I'm wrong. We'll see. Okay. The FRCP provide for a broad discovery of information for the purpose of assisting in the preparation and trial or the settlement of litigated disputes. Under FRCP 26, parties may obtain discovery regarding any non-privileged material that is relevant to any party's claim or defense and proportional to the needs of the case. However, a court may limit discovery if the discovery sought is unreasonably cumulative or duplicative, irrelevant, or unduly burdensome. We're good so far. Lively relies on the fact that the Wayfarer parties previously attempted to subpoena Swift, then withdrew the subpoena and made public statements that they had everything that they needed. And recall that she tried to make it sound like Brian Friedman said that, but actually was just an insider, which is, you know. All right. So we don't actually know who that was. Maybe she's right, maybe she's not. I'm going to say no because, well, frankly, that fits my narrative. So at least I'm honest. She accordingly argues that either the Wayfarer parties never needed communications between Swift and Lively, in which case the Swift RFPs are irrelevant, or the Wayfarer parties have already received the communications, in which case the Swift RFPs are duplicative. Each of these arguments is unavailing. The Wayfarer parties have not yet received any communications between Lively and Swift, so the request to Lively is not duplicative. And the Swift RFPs are relevant. Lively herself has identified Swift as someone likely to have knowledge about complaints or discussions regarding the working environment on the set of It Ends With Us. Lively properly notes that identification of a party in initial disclosures does not necessarily entail that all communications with that party are relevant to the claims and defenses in the case. However, the Swift RFPs are limited to communications about the film It Ends With Us or about this action. Lively alleges that Baldoni and Heath harassed her in numerous ways during work on It Ends With Us, that her concerns about their behavior began early in the pre-production and production process, and that she expressed these concerns in contemporaneous messages. Given that Lively has represented that Swift had knowledge of complaints or discussions about the working environment on the film, among other issues, the requests for messages with Swift regarding the film and this action are reasonably tailored to discover information that would prove or disprove Lively's harassment and retaliation claims. Lively's motion is rooted in the broader concern that the Wayfarer parties are using demands for communications with Swift not to obtain information relevant to claims and defenses in court, but to prop up a public relations narrative outside of courts. But this concern does not justify denying the Wayfarer parties relevant discovery. If the issue is that the Wayfarer parties may leak the requested communications to the press, this concern is addressed by the protective order issued by the court. That order was designed precisely to ensure that parties may share sensitive information that may be only tangentially related to the underlying cause of action without fear that it will be leaked to the press. If the issue is rather that the fact of the request itself has been used as a part of a public relations narrative, this does not mean the request is irrelevant to the litigation or that the Wayfarer parties will not seek to use resulting communications in the litigation. Okay. A motion or request may be, and in this case often has been, both a legitimate litigation tactic and an attempt to maneuver in the broader court of public opinion. The mere fact that the request has been discussed in the press does not render it illegitimate and general and somewhat okay, here we go, I got it. And general and somewhat hyperbolic public statements that the Wayfarer parties do not need the evidence, many of which are not even attributed to the Wayfarer parties but to an anonymous insider, cannot be understood as a waiver or retraction of the RFPs. So basically that statement, which was made by an insider, does not really justify her, saying this is only for public consumption. Okay. Given that the Lively parties have not shown the information is irrelevant or its production would be unduly burdensome, the claim that the Wayfarer parties have dramatized the request in the press does not justify a protective order against the production of responsive documents. Lively's motion for a protective order is denied. Okay, here we're going to talk about the cross motion. Give me 1 second to move this. Okay. The Wayfarer parties' cross motion is also denied. The Wayfarer parties seek to compel Lively to produce documents concerning A, her allegations of sexual harassment and retaliation, B, her communications with Sony, which released the film, and WME, her talent agency, concerning the same, and C, her claims for economic damages. The documents were demanded on February 21st, and Lively agreed on March 24th to rolling production of the documents. Lively states that she has agreed to produce the documents, accept the communications with Swift, and is on track for substantial completion by July 1st. And that's coming up pretty soon. That's the deadline set by the court. Okay. Lively has proposed to the Wayfarer parties that she will produce all documents in the requested categories by the end of this week if the Wayfarer parties produce 1, all video footage related to the film, and 2, full unredacted versions of communications excerpted in the Wayfarer parties' amended complaint and Exhibit A. The Wayfarer parties have declined. Okay. Let's see. There is no reason for the court to order Lively to expedite production when the Wayfarer parties have refused to do so. So basically, he's just saying she doesn't have to do it right this second. Like, she doesn't have to speed up the process, is what I'm understanding here. And if there are any lawyers out there, please correct me. But what I'm getting is, like, she doesn't have to produce it by the end of this week. So, because the deadline is July 1st, so she still has time. The motion for a protective order is denied, and the cross motion to compel is denied. The clerk of court can close those docket numbers, blah, 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 whatever. Okay. All right, so that's it. So I know that they, denied the cross motion, but that doesn't really bother me too much. I kind of get it. If they're not going to expedite their process, then why should she, I guess? And I know that lots of people will say, like, well, there's all these motions to compel and all this stuff going on, but if I'm looking just at this right now, then my snap judgment on that is like, I think it makes sense. So, all right. The thing about leave to file a document. So they wanted to reply to that because Wayfarer had submitted an opposition to her motion for a protective order. They wanted to reply to that before the judge made his ruling. But when they filed that leave to file the document, they attached a copy of the actual letter last night. So, yeah. All right. Let's see. They can't give her the footage to give her the opportunity to modify her narrative to make match. Well, they do have to. They kind of have to produce that. Like, I understand. I don't want her to have it, right? I don't want her to have that, right? But it's pretty relevant to all the claims being made. So I feel like they do have to give her that. I mean, don't get me wrong. I would love to just fight everything and be like, this is so stupid. But I know I kind of get it. All right. Fritz is the lawyer from New York. Friedman added him to the team because he's California. Fritz is, I didn't know that, but I mean, I know who Kevin Fritz is. I don't know much about him though. Why did I think Sunshine was a New York attorney? I mean, there's lots of attorneys here, guys. All right. Not before the deposition. Oh, I'm sorry. I totally misunderstood you. My bad. I mean, I think I get what you're saying. My bad. Damn it, dude. All right. I got tired brain right now, so I'm going to try to go to bed early tonight. Hopefully nothing else comes up for the rest of the day because it's already 7:30, and with all these gray hairs on my head, I should be going to bed by 8. I mean, what's going on here? Anyways, I'll see you guys later. Thanks for joining. And don't forget, I'll have that thing with Shasti up tomorrow morning. I'm not sure what time, but you guys will know as soon as I do. So I'm gonna set that up now. Okay, bye.